With the court's permission, my lord, may I call the matter of SS 163 of 2015, the estate versus Siboniso Miya and 4 others.
Thank you, Mr. Golo.
Please report, my lord, I appear on behalf of accused 1, 2, 3, and 5, and I am present today.
Mr. van der Merwe, it's a pleasure seeing you.
I'm glad to be back.
How are you feeling?
I'm feeling okay, my lord.
Much better. Thank you.
My lord, I confirm my appearance once again on behalf of accused number 4.
Thank you, Mr.
Thank you.
Alexander. Right, Mr. Golo.
Thank you, my lord. When the court adjourned on May 18, my lord, I was busy making submissions insofar as the submission in relation to the further particulars and the reply thereto in respect of accused number 4.
Correct. I think you, let me see. Looks like you had started with 4.9.
I was about to start with 4.9, my lord. May
Right.
I
Great.
then start there as a court, please? My lord, the question there to by accused number 4 is the state is requested to specify at exactly what time the deceased left as per paragraph 18 of the indictment, or rather of the summary of substantial facts to the indictment. The answer thereto given to accused number 4 can be found on page 50 of the bundle, which reads as follows: references made to the record of the bail proceedings held in the Germiston Magistrates Court as referred to in 6.1 of these requests for further particulars. Further, same presently unknown to the state. My lord would recall that on a previous occasion I did make a number of submissions that this section does not apply insofar as the summary of substantial facts is concerned. It is clear from section 87.3 the relevance thereto of the summary to substantial facts. This is exactly, my lord, why it should be noted that the court must guard against evidence being given via the reply to the request for further particulars. The question itself, if you can, one can just look at it. Just give us the time, at what time did the deceased leave? That's the question. State is requested to specify the exact time. Surely, my lord, this is not, has got nothing at all to do with the essentials of the charge or particulars thereto. It goes straight to the evidence which might be given by the witness. However, same has been given, the answer has been given to the applicant that the reference is made to the bail proceedings as well as the same is not known to the state at present. Maybe I should indicate at this stage that from the submissions made by Mr. Alexandra, the state found that in certain instances...
Is it Alexandra or Alexander?
Alexander.
Oh, okay, fine.
My apologies.
No problem.
I'm coming down with a bit of flu this morning. Some might hear that my voice is different.
Okay.
Not that I've been singing all night on the shower, my lord. It's just that winter has come.
You must refuse.
Thank you. There are certain instances where the defense is prepared to accept that I have no problem with the answer if the state says same is unknown. In fact, the submissions there to was the state should simply say is unknown if it's unknown to the state. That will be enough. But as we carry on during the submissions made, there will be answers where the state will indicate, same as presently unknown, but it seems as if the answer is unsatisfactory. I just needed to bring that to the court's attention, because I will show same as I proceed there too. Therefore, my lords, my submission that
You submitted the other day and indicated that according to the law, sections in particular, it is enough if the state states that this is to the state alone.
that is correct, my lords.
All right, fine.
That's correct, my lords. Therefore, it's my submission that no further particularity is needed insofar as 4.9 is concerned. I request to then move to 4.10, which is found on page 10 of the bundle. The state is requested to specify at what time accused number 4 left from the venue or premises as per paragraph 18, should same be known to the state. Without further ado, my lord, Mr.
Just a second. Yeah, no. In fact, it would seem I was just about to say what you were just about
Yes,
to say.
my lord.
It would seem we're moving together.
Yes, my lord.
If
no
I remember
problem.
correctly, 4.10, it's marked settled.
Second, that's correct. I was about to say that, my lord.
All right.
4.11. As alluded to in the defense correspondence dated 28 April 2016 to the state, the defense was handed 3 discs whilst at court on 28 April 2016.
Could you hold it there? I just want to check something.
The court places, ma'am.
You're doing 4.11.
11, my lord.
4.11.
That's correct, ma'am.
Okay, before we get there, am I correct in saying that insofar as 4.12, 4.13, 4.15, and 4.16 are concerned, these are settled, if I remember correctly. That's what was indicated by Mr. Alexander. Could I be correct, Mr. Alexander?
4.10, I've noted that, my lord. 4.12, I've noted that.
Yes.
4.15, I've noted that.
And 13. 4.12, 4.13, 4.15.
I have it differently here, my lord.
Let me see. No. I could be wrong. The 4.13 was not settled? Yes, it is indeed. 4.12, 4.13, 4.15, and 4.16 are settled.
As a court proceeds then, my lord. Let me just note on 4.13 because I've made a note here that I have to respond there too.
Yeah, and then the other thing is, whilst you are there, if I could go back slightly, I just want to verify this. Mr. Alexander, if I could be with you. I just want to verify. Let's go back slightly. If you could go back to 1.14, 1.14, 1.15, 1.19, 1.20, 2.1, 2.2, 2.5.
2.4 as well.
Yeah, the 2.4, yes.
2.4.
It's 2.4, 2.5, 2.6, 2.7 and 2.8 up to 2.11
Correct, my lord.
are settled.
Correct, my lord.
Thank you. You may proceed then, sir.
My lord, I have indicated on my notes here insofar as 4.14 is concerned.
Just a minute. What is the position?
According to me, it's not settled
No, it's not.
as a court.
I said 4.12, 4.13, and then I skipped
4.15,
15
4.16.
and 16 years.
Thank you, my lord.
Thank you.
Thank you, my lord.
Thank you.
May I then, my lord, leave 4.11? Is it circled?
What is settled is 4.10.
It's 4.10.
Yeah.
Court basis, my lord.
4.11 is not.
4.11 is not settled.
Yeah.
Court basis, my lord. Therefore, I was on 4.11.
Yes.
The three discs each contain folders which are, after viewing the defense, is unable to determine the relevance of the content. The state is requested to provide clarity on what the scene depicts. Reference is made to 838 of the copies of the docket. Same can be found on page 51 of the bundle. Without taking it any further, my lord, this is a evidential material containing a video footage. Basically,
Containing?
a video footage.
Okay.
Same could be asked without even requesting the court for further particulars. State, can you explain that to me? What is in there? What does that video footage depicts? Defense is referred to a statement already disclosed to the defense about this individual downloading CCTV footage at a specific place. I seem not to understand why would the state be requested to further or requested for further particulars if same is in the statement. This is a video footage at the corner of Pritchard and Grace. A CCTV which is mounted at the corner of Pritchard and Grace. And if there's relevance to Pritchard and Grace somewhere in the docket, one would make 1 + 1 and it will add to 2. Why do you need the court to force the state to tell you to read the docket and understand the docket? And further to that, what has got that to do with the essentials of the charge? My Lord would recall that on the 18th of April, I have made a number of submissions quoting the relevant passages in the case law insofar as the abuse of process is concerned. May I request that same not be repeated? Therefore, my Lord, it's my submission this. Firstly, the particularity insofar as what it depicts is there in the docket. Secondly, this is an abuse of process. I will skip 4.12, my Lord, because it appears that the state and the defense are at the idiom.
Okay, just a second. You are skipping?
4.12 and 4.13, my Lord. Same seems to be circled. 4.14 reads, the state is requested to provide the defense with the expert report regarding the residue testing which was performed on the fourth ranger that the SAPS recovered. The answer thereto could be found on page 51, which reads as follows. There is no mention on the contents disclosed to the accused that a fourth ranger was recovered. It is hereby requested that the accused disclose the information to the state that they are in possession of in relation to the recovered fourth ranger. We are dealing now with evidential material. The state is requested, in terms of Section 87 of the Criminal Procedure Act, to provide a residue or prima residue test of or found at any vehicle referred to as the fourth ranger. Evidential material. Now, what is strange about this request? And I would make submissions that it forms the core of my submissions that is an abuse of process. The accused himself says to the court, there was a fourth ranger vehicle that was recovered by the SAPS. Such is not part of the state's case. There is nowhere in the docket where same has been indicated by the SAPS to say we have recovered a fourth ranger. On what basis, therefore, my lord, is this question requested from the state? My understanding is that after being given or the docket has been disclosed to the defense, it contains all the evidentiary material the state relies on in proving the state, or rather the case against the accused. I still want my colleagues to show me in the docket that I have disclosed where it is referred to that a fourth ranger was recovered. If one looks at 4.13, they first ask, give us the particulars of this fourth ranger. Knowing very well that there's nothing in the docket that says it has been recovered. So give us the particulars. The very next answer says, if the prima residue is not saying, in fact, if, it's saying, give us the prima residue testing of the fourth ranger recovered. Now, the state is saying on the reply, we request, in order to assist the accused in getting this expert report of the residue, give us the details of this information. Where is this fourth ranger? We'll simply go and get it. And then do the prima residue testing and then give it to you. That's all that is meant when you say it is hereby requested that the accused disclose the information to the state that they are in possession of in relation to the recovered vehicle, so as for the state to assist with getting the prima residue or the residue testing as is requested by the accused. Because it seems as if the accused is in possession of certain information the state is not in possession of. Why, my lord? Why is this court asked to do such? Why is this request made? There's something sinister. Perhaps during the trial, same will be exposed. There's something sinister about this fourth ranger that the accused seem to be aware that it has been recovered. The submissions made by my colleague was, same was found in the newspaper articles. I do not recall ever submitting any newspaper articles about the recovered Ford Ranger and disclose same to the defense for them to request this particularity. Why do we bother the court with such issues in the disguise of Section 87 application? However, my lord, the answer there too is, we don't know of any Ford Ranger recovered. I was hoping Mr. Alexander was going to say, same is settled, because I have indicated on page 51, 4.14, that on the contents disclosed, there was no Ford Ranger recovered. Therefore, it goes without saying that there can be no residue that could be tested on the said range. Therefore, if the court wants to order the state to disclose this evidential material, which is not part of the Section 87 application insofar as the Act is concerned, the accused must inform the state. Where is the Ford range? We will simply go there, seize it, do the testing. May I then skip 4.15, my lord, and 4.16 because it appears same is circled. And then go to add general. .1. The state is requested to provide the defense with copies of all the MoneyPoint records or registers in which the transactions between MoneyPoint and its customers were recorded for a period July to October 2013. Mr. Alexander made submission that this is needed because I'm not sure that is the state, that is the accused version. But if my assumption is correct, his version is that there was money loaned by MoneyPoint to the deceased, or the deceased borrowed some money from MoneyPoint. It was also during his submissions that he mentioned the issue of the organs of the state having certain information which the accused requires. If my memory serves me well, he also mentioned some certain passports of accused number 4, which has been seized by the, not passport rather, diary. That has been seized by the organ of the state, the diary which belongs to accused number 4. Nowhere in the charge sheet or nowhere even in the summary of substantial facts that there's an issue mentioned about the deceased or rather about the link between accused number 4 and the business of Money Point. If my lord reads 5.2 just under 5.1, the court will realize that this business was ran by some shareholder called Mr. Ronnie Vuma. What is interesting, my lord, is that an organ of the state has seized certain documents in pursuance of a criminal trial against this Money Point, against the business called Crosspoint, which Ronnie Vuma was linked to, and accused number 4's wife was linked to. If I can pause at this stage and indicate to the court that even during the bail application, accused number 4 distanced himself as far as possible on the business of Money Point. It had nothing to do with him. Now there is a fight between Crosspoint, wherein accused number 4's wife is linked to that business, and the state, wherein certain procedures were followed insofar as seizing documentation of Crosspoint, which got nothing to do with this case.
Are you saying Crosspoint?
Crosspoint.
Are we talking of Crosspoint and Money Point?
And Money Point. It's a
two separate entities.
My lord, Money Point is a trade. Crosspoint trades as Money Point. This is if you read at 5.2, my lord.
Just a minute.
Crosspoint P242 was the owner of Money Point.
Okay, yes.
Yes.
Yes, fine.
I just want to indicate to the court that accused number 4's wife is linked to this Crosspoint 242 P2Y Ltd. Now, the allegation by the state is the deceased borrowed number 4 money. What are the allegations? Once again, if my assumption is correct that this is the accused version, that this Money Point actually borrowed money to the deceased, it's like if that's the accused version, I don't know, but it's recorded in terms of this particularity. So if needs be, you'll be cross-examined on it. Why would this court, this specific court, instead of accused number 4's wife or whoever is representing him, or this Ronnie Vuma if he's still alive or whatever the case may be, why don't they attack the very same organ of the state that seized the properties, or that seized the documents rather? Because there was a process that was followed there. In trying now to use this court to obtain those documents, which are not relevant to this case, but to the other case, via the application in terms of Section 87 of this case, knowing very well that this Money Point business is not relevant to this case. Why would the accused do that? Why would the accused abuse that process? There is no mention of Ronnie Vuma. in the indictment. That is why, my lord, the case law is so clear. Counsel should stay away in abusing the process of Section 87. A typical example of what I'm talking about. Mr. Alexander made submissions that the accused diary has been seized by the members of correctional services. So it is in possession of an organ of the state. The accused will need that diary in preparation of this trial. What the court is not told is the following. Not by me, by Mr. Alexander, who is supposed to have told the court. The accused did approach a court to force the organ of the state to release the diary. And the court dismissed that application. There is a court order standing that the organ of the state is not going to give you back this diary. Now,
You're saying application was dismissed?
was dismissed. And the accused is aware of it. And Mr. Alexander is aware of it. But now, this court is asked, no. The other organ of the state has got my documents which I need to use to prepare. This court must order the state to disclose same. Knowing very well that there's a court order. Why abuse the process? Further to that, we are referring to a 2013 incident. And the diary refers to an incidents of 2015 and 16.
(2015 and 2016) incidents.
Incidents, my lord. My submissions, therefore, in 5.1 spill over to 5.2. I still maintain the state is not in possession of same. It does not form part of any of the charges, and it has no relevance herein. .3, my lord. And 5.4. May I confirm that on the 18th of May, same was handed to the defense. Before I proceed, may the court confirm with both counsel.
Just a minute. Given to both counsel, to Mr. Alexander.
Both were here. I'm not sure whether I've given one copy and then the other will do his copy from that one. I can't recall, but there's a copy that was given.
Anyway, they will clarify.
Thank you.
Thank you. Shall I start with you, Mr. Van der Merwe?
I received nothing. I know that the investigating officer gave a disc or a couple of discs, I'm not exactly sure. Mr. Alexander indicates 3 discs to Mr. Alexander. He also indicated when he gave the disc to Mr. Alexander there is others outstanding which he will give to us. I do not know what are on the discs as I have not received. Mr. Alexander, I understand, is busy printing the contents thereof now. Seems to be voluminous.
Are you saying that there are discs which were given to Mr. Alexander?
Yes, indeed, some of them. The contents of the discs are unknown to me. The disc was supplied with a promise of further discs to be supplied.
Now, the promise that you're referring to, was it referred to Mr. Alexander?
Pardon me, ma'am.
The promise to furnish more discs, was it referred to Mr. Alexander or to both of you?
It was to both of us. We were actually standing there after the adjournment.
Thank you, Mr. Vandermeer. Mr. Alexander, just a second. Your response, the question is, could I then ascertain as to whether or not this was not finished to the defense on 18 May 2016? Anything given to you?
My Lord, Colonel Ganinda, who's present, handed me 3 discs.
Just a minute. Colonel?
Ganinda, the investigating officer who's present
Okay.
next to my learned friend.
Just a minute. 3 discs.
3 discs, correct, my Lord. Containing, I was told that it contains cell phone data. And each of the 3 discs relates to a different a network provider. In other words, MTN, Vodacom, and I believe it's Cell C.
MTN, Vodacom, and Cell C.
That is correct. That is
Thank
what I was told. Those are the annotations also on the discs. There's
Okay.
consternation at my office currently because they've been printing non-stop. It's to say it's voluminous, my Lord, would be to put it mildly. I'll still have to try and fathom who it relates to, etc. What I can also add is we were told in no uncertain terms that it is not complete, that there is still information forthcoming, or that will be forthcoming in that regard. My Lord will remember previously it was indicated as well that the state subpoenaed the relevant network providers. My learned friend for the co-accused actually indicated this, and some of that information I was told by the investigating officer is still outstanding. So, as I say, we have 3 discs
And
containing Vodacom,
still more
MTN,
to
and South-
still
and
more
there's
to
still
receive.
come, yes.
All right.
That is,
fine.
I cannot. I still haven't been able to fathom out which cell phone number belongs to whom. That I'll still, at the appropriate time, I will address those concerns to my learned friend for the state, and hopefully we can resolve them without having to resort to court.
From what you're saying, could I be getting an indication that this is one of the aspects which could very well be easily sorted out between
I believe it can
the
be.
state and the defense?
Yes, I believe it can be, my Lord. It's particularly pertaining to which cell phone belongs to whom, I'm not too sure. My Lord will see when my learned friend for the state goes on, he indicated that accused number 4 in the request for disclosure and for further particulars didn't indicate which cell phone numbers belong to him. So we'll still need to fathom that, but that can be resolved. That shouldn't be an issue. I don't
All
believe
right,
we
fine.
need
I'll
to
tell you
go
what.
according to that.
The reason why I ask this is simply because sooner or later I must give a ruling.
Yes, correct.
And I need to know on what I need to concentrate. So that will assist me a great deal.
I'm indebted to
If I could be informed accordingly, don't worry about this, don't worry about this. And it was for that reason that I wanted confirmation as to which paragraphs were regarded as settled. So that as I move and as I arrange my judgment, I need to know exactly what I have to deal with and what not to.
It's understandable. Thank you, my Lord.
Thank you. Mr. Gawa, if I may come back to you. You recall you actually had asked the court to get confirmation, as you had requested. Could this be an answer to what you had requested the court to do?
My Lord, my answer is in two folds. Number one, my investigating officer who just came in informed me differently to what my colleagues are saying. However, in view of what my colleagues are saying, that this can be settled outside, we need now to confirm whether should we not deal with 5.3 and 5.4 altogether, or should I respond there too?
Okay, just a minute. With 5.3 and 5.4.
And 5.4 minutes. It seems as if there's an understanding of saying we can deal with this outside court, but because my investigator is saying, insofar as whatever can be added.
Yeah.
Yes, he confirms 3 discs were given, MTN, Vodacom, and CLC.
Yeah.
However, the other part of it, he says it's different to what they are saying. But I don't want to put that.
You're referring to what was to follow?
What was to follow, yes, madam. But
all right, fine. But
I just need to, so that I should not burden the record with that. If 5.3 and 5.4 we're saying we're going to settle this outside of court, we don't need this court to, then we can do that, and then I'll stop.
Yeah, in fact, that will be very important because it will assist me as well. Mr. Alexander, with regard to your proposition, what do you think? Is it not be prudent? Will it not be prudent that 5.3 and 5.4 be left out for now, or entirely? Because if there is such a possibility that could be sorted out, then that could be done outside court.
My Lord, if I may make a suggestion, may I suggest that we let it stand over until after the tea break? By that time, I believe we would have resolved. I'll approach my learned friend as well as the investigating officer during the course of the tea break.
So, in other words, Mr. Gawa could then proceed with the other paragraphs.
Correct. No problem with that at all, my Lord.
Right. Fine.
Thank you.
Is that okay with you, Mr.
I think it's proper, my Lord.
Yeah, that's a second. Thank you, sir.
Thank you, my Lord. My Lord, I also believe that 5.5 is one of those that can be discussed outside court. Because it seems we are at idiom that what is requested as part of the record is just that you have to compare whether what I gave to them and what I have is the same thing.
All right.
Because they say they're not prepared to admit it unless they are shown that is the same thing. I think this can be clarified outside court unless
Right.
Mr. Alexander have it otherwise.
Yeah, Mr. Alexander, do you agree?
I fully agree. That's what we suggested initially. Thank you.
Right, thank you.
Thank you. 5.6, the state is requested to provide the defense with a list of names of people whom the defense may not approach to obtain statements other than those alluded to in the indictment. The reply thereto is as follows on page 52, the very last page of the bundle, my lord.
Yes, I'm there.
All those witnesses who have made statements already disclosed to the accused, including those mentioned and those not mentioned in the indictment. Let me stop there. It appears this sentence is not understood by the defense. Witnesses have made statements already disclosed to the defense. Therefore, those witnesses who have made statements should not be contacted by the defense.
Right.
Further to that, the witnesses who have made statements, some of their names do not appear in the list of witnesses. For example, A77.
Just a minute. Yes.
If I can clarify, my lord, there will be a statement deposed or an affidavit deposed by witness X or Lawrence Gaba, which is A66.
All right.
For some reason, the state decide not to mention his or her name on the list of witnesses in the indictment, which will be public knowledge. There's a reason why a name is not given there.
Also, in other words, that has not been reflected
In the list.
on the strength of a section,
Yes, my lord.
which says the state may not necessarily, if the following will be
That's
the
correct,
result.
my lord. That's correct, my lord.
Just a minute. In fact, for security reasons.
That's correct, my lord.
Which effectively means that the presence of the statements or the affidavits in the police docket will inform the defense as to who the
That's
witnesses
correct.
are.
That's correct,
And
my lord.
therefore take note that if you don't see the name there, understand that it's been done for security reasons.
That is correct, my
All
lord.
right, thank you.
That is correct. That's basically what that sentence says. That
All right, fine.
you will find a statement, but the name might not appear in the list.
All right, fine.
And then the paragraph goes on further to say, all the persons whose names have been alluded to in the statements already disclosed to the accused. There are statements disclosed, and then certain names given to those in those statements. I will
Ma-
make an example.
Yeah, I just wanted to ask you this person. There is a statement
That's correct, ma'am.
which is by so and so,
So and so.
A for instance, and it makes reference to B
That's correct, ma'am.
in the body of the statement.
In the board of
Is that what
statement.
you're referring to?
That's exactly what I'm referring
Just a
to.
second.
Yes.
Right, thank you.
On top of those names or B and C, which is referred to in by A. There's also a name of Glenna Gliotti.
Okay, just a second. Yeah.
And the two others mentioned on paragraph 5.6 in page 52, my lord. This all that was requested and replied to are the names. Basically, nothing more. Therefore, the reply is that my submission sufficient. Give us names, we give you names. $5.7 million. The bail record or the bail transcripts wherein accused 4 and 5 were applicants. If my memory serves me well, my lord, I did make submissions on the 18th that the same was given to the accused already during the bail application.
Yeah, if I remember correctly, what you said was that transcripts were procured, and in fact, the accused themselves did that and provided you with a copy.
That is correct, my lord.
I remember.
That is correct. Why would then there be a duplication? And in trying to force the hand of the state, one uses Section 87. If my memory serves me well, my lord, I did make submissions even on the previous occasion to say, I understand and appreciate the fact that my learned colleagues present today were not instructed at the time. It was a different law firm altogether. My understanding, I think I said this even on the last occasion, counsel whose mandate has been terminated must hand over to the new counsel whose mandate has now been instituted.
Yeah, you dealt with it, I remember.
If there's no agreement there, for whatever reason, this is not a proper forum to deal with that. This court cannot be used to deal with that. My understanding is the accused pays for services of cancer, inclusive of everything concomitant to the charges he is facing. They are in possession. The accused is in possession of the record. To put it perhaps differently, this is one of those instances where the parties can try to sort of talk about it outside to see if there's any form of agreement that can be reached.
Just a minute. Regarding this aspect, whilst in my corner, I looked at this and I asked myself, in trying to think aloud, whether this, as you are now correctly pointing out, could not be sorted out as you are indicating. I think, in all fairness, Mr. Alexander may be favorably disposed to agree with the proposition. What could your view be, Mr. Alexander, with regard to this aspect?
My Lord, I'd love for the parties to be able to sort it out, and I'm thankful for my learned friend for conceding that it can actually be sorted out. We can perhaps also discuss it during the tea interval and revert to the court, my Lord, on resumption.
So could we then safely leave it at that?
At this stage, yes.
Yeah, just a minute.
There's only one challenge that I might have, my lord, is there are certain statements or affidavits rather that were handed in court which were not particularly read on record. And the copies that I have certain notes with me that are in preparation of this trial. I might have, but we'll discuss this with my colleagues. I don't know how we go around it.
Yeah.
Certain affidavits that were handed in, because now I've made notes before the commencement of this trial consultation. And if they don't have that, then, because some of the, I remember from the top of my head, some of the statements were not read on record, they were just handed in.
Yeah.
So, but we will discuss that and see how
yeah, you could find a way out, you know. And that's all right, thank you.
That way is called Tipex, my Lord.
Well, that's one of the ways.
Yes.
Thank you very much.
it's a lot of work, but however. Well, therefore, can it takes me to paragraph 6 now of the request by accused number 4.
Yes.
Starting with 6.1, which reads, the state is requested to state in respect of every count who the accused were that acted in common purpose with each other in respect of each and every count. Now, to demonstrate to your Lordship.
Are you getting to the summary?
That's correct.
All
To
right.
demonstrate what section 87.3 is there for, I'll start with count 1. It reads in that during the period July to September 2013 in Etor near Bedfordview, other places presently unknown to the state in the district of Germiston, and Johannesburg, and other places unknown to the state, the accused unlawfully and intentionally conspired among themselves and with other persons presently unknown to the state to aid procure the commission of an offense to commit murder, to wit unlawfully and intentionally kill Sam Issa, a male person. That is the charge. Now, the state is requested to state who of the accused acted in common purpose. I'm just stating count 1. Now, as 87.3 says, in determining whether a particular is required or whether a defect in the indictment before a superior court is material to the substantial justice of the crime, the court may have regard to the summary of substantial facts under paragraph A of section 144 subsection 3. Now, if we look at the substantial facts in this indictment with reference to 87.3, it says, paragraph part A, paragraph 1 and 2. Accused 1, now we're trying to answer 6.1. Who of the accused acted in common purpose? Here's the answer. Accused 1, Mia, in brackets. Accused 2, Mafunda, in brackets. Accused 3, Memela, in brackets. Accused 4, Krejcir, in brackets. Accused 5, Grigorov, in brackets. And others acted in the furtherance of a prior criminal arrangement and or common purpose to commit the crimes as set out in counts 1 to 9. There's the answer. Who of the accused? There's the answer. That's exactly what I meant in the beginning, my lord. That the submersion, what is meant by section 87.3 is exactly what I just indicated to the court. Hence, the answer to 6.1 is on page 52 of the bundle. The reference is made to paragraph 1 and 2 of part A of the summary of substantial facts to the indictment. (6.2) encompasses 6.2.1 to 6.2.11, which is broken into pieces or semi-paragraph. What was the scope, mandate, and purpose of the common papers? Who were the parties to the common papers? When exactly did accused become a member of the common papers? How did each accused associate himself with the alleged common purpose? These are all these questions. And the reply thereto is reference is made to paragraph 1 and 2 of part A of the summary of substantial facts. Let us read what paragraph 2 says, my lord, on page 7 of the indictment. As to precisely when, where, in what manner the prior criminal arrangement was entered into, and or how the common purpose was formed, and or who all the other parties thereto were, except of course for the accused, is at present unknown to the state. The scope, mandate, purpose of the common purpose is unknown to the state. Who the parties were to every count is unknown to the state. When exactly did each accused become a member of the common purpose is unknown to the state. How did each accused associate himself with the alleged common purpose? There. How the common purpose was formed is presently unknown to the state. There's the answer. Despite, my lord, what is contained in the statements already disclosed, wherein one can, of course, elucidate what the evidence is showing common purpose without indicating to the court exactly. We're not at that stage as yet. What was the benefit derived from the alleged actions of accused number 4 from each and every accused in respect of each of every counts levied against accused number 4? Still one and the same thing. What common purpose did he derive, or what benefit did he derive from that common purpose? And with the greatest of respect, my lords, part B of the indictment explains exactly what happened. This is the beauty of the constitutional era.
Are you saying part B of the indictment or part B of the summary?
So part B of the summary. My apologies, ma'am. Part B of the summary. It explains exactly what is being asked here, so as for the accused to understand what is facing. Which brings me to some comments by the retired Judge Swalsman in the matter of State versus Livingston, which was supposed to be reportable, but here's the judgment, my lord, from this very same court.
Thank you.
If we look at page 2 of this judgment, my lord, under the heading, the principles to be applied to my decision. Against line 6.
Where reference is made to State versus Cooper.
That's correct, my lord. Just after that, my lord.
Okay. The prior.
Yes, that's correct, my lord. Prior to the Constitution, an accused indicted in the High Court was, in terms of Section 144, subsection 3A of the CPA, afforded 2 additional means to assist him or her in the preparation for trial. The first was the requirement that the indictment be accompanied by a summary of substantial facts of the case, sufficient to inform the accused of the case against him, and that would not prejudice the administration of justice. This is what Judge Sussman said in 2006 on the 20th of December. What is being asked on 6.2, if one wants to know, if the accused wants to know, there is an additional element, rather an additional mean to assist him to prepare. Perhaps let me just indicate. Maybe it might assist. What was the benefit derived from the alleged actions of accused number 4 from each and every accused in respect of each and every of the counts levied against accused number 4? Paragraph 5 to paragraph 7 of the summary of substantial facts. I'll just, by way of an example, show what I mean. Accused number 4, who assumed the position of a crime boss, would at times give instructions to the above mentioned and others to commit certain offenses for and or on his behalf. Accused 4 will then pay his co-accused for same. What was the benefit derived from the alleged actions of accused number 4 from each and every accused in respect of each and every count? Yeah. During the period that I'm reading from page 8, paragraph 6 again. During the period that deceased was an associate of accused number 4, he came to know and came across accused 1 to 3. During the time that the deceased knew and was an associate of accused number 4, he, the deceased, lent amounts of money to accused number 4. The agreement was that accused number 4 would then repay the deceased that money. It goes on and on and on and on, Read the summary and then you'll find answers to the questions you are asking on 6.2. That is why Judge Sussman is exactly saying in this Livingston judgment. If the court can just bear with me.
All right.
For example, I'm trying to just make the court understand my submissions. 6.2.7. What did each member of the common purpose as alleged by the state and identified by the state in respect of every count do in the furtherance of the said common purpose? Now, if we take advice from Judge Sussman and look at page 10 of the summary, rather page 10 of the summary of the indictment, and paragraph 18 to 20. There are preceding paragraphs which indicate what happened between accused number 4 and the deceased insofar as monies that have been loaned. The deceased was in the company of accused number 4 and other people from the night of the 11th of October 2013 to the early morning hours of 12th October 2013. The deceased thereafter left for his home driving in his Audi Q7 with registration number WHK932GP. Paragraph 19. En route home, the deceased was stationed in the traffic intersection of Smith and Bradford Roads in Bedford View. He was approached by a white Ford Ranger vehicle fitted with blue lights and siren and other vehicles presently unknown to the state. In the said Ford Ranger, there was
An omission.
An omission. I choose 1 to 3. Then paragraph 20 says, the occupants of the said Ford Ranger fired several shots with automatic rifle or rifles at the deceased vehicle. The occupants of the Ford Ranger we are saying I choose 1 and 3 was there. Now, if you look at the preceding paragraph, the state has indicated that there was a dispute between accused number 4 and the deceased. Now, we also said in the summary of substantial facts, number 4 used to instruct the other co-accused to commit certain offences for them, including this one. This person says, I owe him, go and kill him. This is exactly what is there in the summary of substantial facts. Why do you ask the state to say, what did each member of the common purpose allege to do, whereas same can be found on the indictment? I will also illustrate the example as well now. If one looks at 6.2.9 on page 14 of the bundle, is it, that is the request for further particulars, is it alleged that the common purpose was derived by express agreement? And if so, the state is requested to set out the terms and conditions of the express agreement. Let us look at paragraph 2 on page 7 of part A of the summary of substantial facts. As to precisely when, where, in what manner the prior criminal agreement was entered into is presently unknown to the state. As to precisely in what manner the criminal agreement was entered to is presently unknown to the state. You read the indictment, you read the summary, you go and ask the very same question. Is it alleged that the common purpose was derived by express agreement? And if so, tell us. But the summary says we don't know already. We don't know in what manner it was formed. That is why it was said in R versus Muilwanyana, M-O-I, my lord, L-W-A, N-Y-A-N-A, and others. 3. So 1957, volume 4, SA Law Reports, against page 608, Transvaal Division, on 617E to 618A. The request for further particulars may not be aimed at putting every conceivable question to the state, especially if this is intended intended rather to prejudice the state rather than to obtain information to which the accused is entitled. This is exactly typically what this case is saying. Do not request for particular where it's not necessary to do so, with an intention to prejudice the state. We should guard against this. (6.2.10), for example, if it is alleged that it was inferred from the conduct and the facts and circumstances, that is still on page 14 of the Bundle Malot.
Yeah, thank you.
The state is required to specify the conduct, the fact, the circumstance, and utterances on which the state will rely in order to draw the said inferences. Why is it the duty of the state to draw those inferences, Malot? Or is it the duty of the court, upon listening to the evidence and then finding what are the proven facts, in order for the court to draw an inference whether the state has proved its case beyond reasonable doubt? Why is it the duty of the state to just make inferences now and tell the defense, look at paragraph 1, 2, and 3. My inference is that this is what has happened. Is that not really, in all respect, my lord, the question of evidence?
Just a second. Could it be my understanding then that as you say so, you are saying this is premature?
It's premature, my lord. It's premature. More especially if we look at the paragraph I referred by Lord to in the Yu Chen Chao matter on page 32, paragraph 64.
Yeah, just a second. Paragraph
64 on
Yeah.
page 32 of the Erasmus judgment, my lord.
Okay, right.
Where the state already supplied its entire police docket to the defense. The defense is, as it were, appraised of all the evidence in the form of witness statements that it has to face. Now, the docket is supplied. You are saying, from what you supplied to me, tell me what are your inferences, state? What are your inferences? That is the matter of evidence. In trying to use Cooper, who applied at the pre-constitutional stage, where the defense had no clue what was the evidence against them, because they were not privy to the contents of the dockets. In this present era, with such experienced counsel, to come and ask the state, tell us your inferences. Tell us what are the inferences that tells you that A did this. It's the understatement. Requiring the state to expound on these would be regarded as a matter of evidence, as the state cannot be expected to anticipate and further expound and likewise presuppose replies to evidence tendered in the examination in chief or cross-examination in terms of the witness statements filed in the police docket. That is exactly why paragraph 64 is so important. To presuppose a state now to say, because it is mentioned on paragraph 2 of A77, the inference is that A, B, C, and D. It's a matter of evidence. The witness will come in and testify. May I stop them a lot and that we adjourn for the tea?
All right. They got agents for tea.
All right.
Yes.
It's 20 past, so we'll come back at 25. We'll take our 15 minutes. I am sure you feel half past 9. I'm not pushing you one.